So before we proceed with the various stages of a civil proceeding, let us first examine the Commercial Courts Act of 2015. The Act in itself has become very important and relevant today because it seeks to determine the procedure for how a commercial dispute is to be filed before a particular court. Now, what was the purpose? Why was there a need felt for a specific legislation like the Commercial Courts Act of 2015? Prior to 2015, the decade that preceded it, India was continually receiving a lot of foreign direct investment into the country. With the onset of that investment into the country, there were various types of commercial disputes which the courts had to deal with. Now, one very interesting facet of most commercial disputes, also because it relates to decision making by the organizations that have to contemplate filing such a dispute, it's important that a specific timeline is adhered to. The system that adjudicates that dispute is efficient and there is clarity in terms of both timeline and efficacy of resolution. So with that idea in mind, so that all sorts of commercial disputes can be adjudicated by the courts in a timely manner, in the most efficient way possible, the Commercial Courts Act 2015 was formulated. So there goes the purpose of the legislation. But despite a new framework being put in place, how different is it from the Code of Civil Procedure? Let's examine that. One of the first things that the Commercial Courts Act envisages is what qualifies as a commercial dispute in the first place. A commercial dispute, to explain in the most simplest of expressions, would be a dispute which relates to a business, which relates to two parties who are both commercial parties and seek to do it in furtherance of their business. Now, of course, under the Act, under Section 2 of the Act, there is a whole host of disputes that have been identified as what constitutes a commercial dispute. Let's look at the Act for a moment. Commercial dispute means a dispute arising out of 1. Ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. Now, what are mercantile documents? Those are documents that are executed by merchants or businessmen in the course of their business, in the ordinary course of business. Issues relating to admiralty and maritime law, carriage of goods, construction and infrastructure contracts, including tenders, agreements relating to immovable property used exclusively in trade or commerce. So these are just some of the examples. The Act, of course, envisages a whole list of such commercial disputes.